Hello and good afternoon. I'd like to welcome everyone to today's webinar, STEM OPT and CAP in 2019. Excited for this presentation today as our week comes to a close. Before we move on, again, just want to go over a few housekeeping items. This webinar is being recorded, and the recording will be sent out along with the slide deck tomorrow afternoon, so please keep an eye out on your inboxes for that email. You'll also receive, all attendees will also receive some continuing education credits from HRCI and SHRM. Those will also be included in tomorrow's email, and they're at the end of this presentation for everyone to copy down. Again, if you have a question you would like to ask, please do so using the GoToWebinar control panel that you see on the right-hand side of your screen. Type that question in, and we'll try to answer that when we get to the question and answer session. All right, so for nearly 20 years, Envoy has been on a mission to fix the confusing, frustrating, and inefficient immigration process. We combine expert legal representation with innovative technology to deliver the only solution that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in 150+ countries, has grown 46% year to date, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And back for the second webinar this week, I would like to introduce Sarah Herbeck, Managing Partner at Global Immigration Associates. Sarah is responsible for all legal service delivery. Sarah and her team work with clients to establish corporate immigration policies and procedures, along with training and educating clients through webinars and presentations to HR and talent acquisition teams to ensure immigration policies are applied consistently. Sarah graduated with honors from Northwestern University and received her JD from Chicago-Kent College of Law. Sarah, welcome back.
Thank you so much, Eric.
All right, so before I kick it off to Sarah, I just want to provide a brief agenda, kind of some main parts of this presentation. What is OPT and STEM, rules for employers, navigating the requirements, CAP, and then some parting words, and then we'll end with some questions. All right, Sarah, so my question to you, what is OPT and STEM OPT?
Well, as you know, since you gave the introduction, we're going to focus on STEM, but we first need to lay the groundwork as to what these lovely acronyms are. For those of you in the immigration world, acronyms are the name of the game, and these are two very important ones, particularly as you and your companies gear up for the H-1B CAP season, which is quickly approaching. So OPT is optional. It stands for Optional Practical Training, and STEM OPT stands for Science, Technology, Engineering, Math, Optional Practical Training. These actually confer work authorization, these status, the OPT and STEM OPT, but in different ways. So OPT is generally granted work authorization to a foreign national student after he or she has graduated from a U.S. institution and received a bachelor's degree or higher. Typically, the individual foreign national will receive 12 months of work authorization in OPT status. And it's available to those individuals who take what they've graduated, like what they've learned during their graduate or undergraduate studies in the United States and apply that. So it is a training session. It's those entry-level positions where individuals are really beginning to understand the background of theoretical knowledge that they obtained while they were in school and practically applying it in their position. So you're going from being a computer science major, as an example, to being an associate software developer, as an example. So we take the classroom from a background perspective, and you get the practical application of your background through the Optional Practical Training program. Again, that typically lasts for 12 months. There are exceptions, but the general rule is a 12-month time frame. The STEM OPT is a supplement or an add-on to the OPT. And the STEM OPT adds an additional 24 months of work authorization to the individuals who work for employers that meet the minimum requirements for the STEM program, and then ultimately employ a foreign national who has a STEM degree. Now, Immigration Customs Enforcement, also known as ICE, has a very specific list of those majors that are considered STEM majors. To qualify, we're going to run through the various items, but the bottom line of it is the employer, very two simple rules before we get to sort of the nitty-gritty. One, the employer has to be a participant or participate in the E-Verify program. And two, the individual foreign national must have a STEM degree as confirmed by ICE. Those lists of degrees and very specific codes are easy to find, and certainly if you have any questions as to whether or not your foreign national employees do qualify because you're an employer who participates in the E-Verify program, certainly reach out to your immigration provider. He or she will definitely be able to let you know whether or not this additional 24-month period is going to come into play or be available to you and to your employee. So specifically, what is the STEM OPT? Again, it is an extension of that optional practical training that was described post-graduation. It allows for individuals who have the STEM degrees to participate in further work authorization and training in the United States. In order to qualify, there are a variety of factors that come into play, but most specifically are some very unique rules that we need to be mindful of because they are important. First and foremost, in order to apply for the STEM OPT, the students, as they have the control over the application itself, they need to make sure that they're still in their OPT status, and then to be able to apply. So if their EAD has expired and they're not in a cap-gap situation, they're not going to be eligible for that 24-month period. And so making sure that you have regular conversations with your foreign nationals that you know, one, are in F1 status, and two, have the opportunity to apply for the STEM OPT, certainly that's a situation where you'd want to be mindful and ensure that the students are assuming responsibility. Now, there are some employers out there who do help and participate in that process more than just providing the documentation that's necessary for the students to apply for the STEM OPT extension. But general trends are that the students really are the driving force behind these applications. And so it is important to remember that they need to be in their OPT status, so everything's still valid, in order to receive and apply for that 24-month extension. So essentially, there are some general benefits of what the STEM OPT brings to the table. It's a furtherance of learning. It certainly helps in this day and age in STEM industries, having those students who are really at the cutting edge of their theoretical studies at universities in the United States be eligible for not just that 12-month period, but a total of 36 months. It also gives employers an opportunity to determine if they want to make a longer-term investment in the employees as to whether or not future sponsorship is a choice that is going to be made to support a longer-term employment for the foreign national employee. And it also, just sort of as a general mechanism, allows for students to understand the American workforce and what it means to be lawfully employed and have lawful status in the United States, and what it's like to be in the U.S. worker mindset and culture and how really companies work in the United States.
Great. So you kind of briefly talked about some rules for the employees, the students. What can you tell our audience about rules for the employers?
Sure, certainly. As I said, sort of the general baseline rule that employers need to understand is that you must, in order to employ and have employees, foreign national employees, benefit from the STEM OPT, the employer, him or herself, or the company, must participate and use the E-Verify program. Now, I think that a lot of individuals listening to this right now probably work for employers who utilize the E-Verify program, or work for employers who potentially would like to use or are considering using the E-Verify program. If you're in the latter two categories, I really do encourage you to discuss internally amongst your company regarding and looking at kind of holistically at who you're recruiting on a very kind of new entry-level position standpoint, what your goals are from an employment perspective, both immediate and future. And I certainly encourage you to speak to either internal counsel or external counsel to discuss the benefits and also the risks of participating in the E-Verify program, and what additional obligations you have just simply outside of STEM OPT. So it really is an important consideration to look at your whole hiring and record retention compliance program holistically versus just sort of tunnel vision. This will allow me to employ and have employees using the STEM OPT program. So while I think it's great for those individuals who fall in and meet these qualifications, it certainly allows for additional opportunities to apply for the H-1B cap, which I know a lot of people are getting ready for and geared up for now. I know myself and my team are doing just that. So it definitely allows for opportunities, but a holistic approach, if you're not a current participant, is certainly something that I would generally say is a good idea before beginning. And as most employers do, you need to have your Federal Tax Identification Number, or FEIN. And then finally, you need to have a nexus of why you hired the employee based on their degree. So it's very similar, again, for those of you who are gearing up for H-1B cap season, for having, say, a chemist. I gave this example 2 days ago, position opening, an entry-level chemist position opening, and hiring an individual with a biology degree, a bachelor's degree in biology. So just being able to understand the nexus. So having a chemist, but having a bachelor's degree in economics, you might be running afoul of what the point behind the STEM extension is for, or even the OPT from an initial standpoint. So just be mindful, and I can only imagine that this is looking at your general hiring practices to begin with. So having something that's out of left field doesn't generally happen. I know there are always exceptions to rules, but just, again, wanting to make sure that there's a nexus, a reason behind hiring this particular foreign national employee in this particular position. There's also some additional work that employers need to do that was instituted by DHS and implemented by DSOs and the school officers in charge of this program and in charge of assisting the students in applying for and receiving the STEM OPT. What was instituted is a formal training plan. It's the Form I-983, and it's several pages long. It has ongoing obligations not only to the student but also to you as a STEM OPT foreign national employer. One, making sure that you have a plan in place, and I think that most employers, if you're looking at training, particularly your entry-level employees, there is a plan in place. Is this plan the same for every employee? It could be. You could have a fairly robust training plan. If not, and you tailor it to each individual employee based on his or her needs, that's fine too. But what it comes down to is, in completing the I-983, you need to be able to tell the universities what you're planning on doing with this particular student and how that student's theoretical knowledge obtained while getting their bachelor's degree, master's degree, or PhD is going to be utilized by or through this additional 24-month period with the STEM OPT. In addition, there are reporting requirements and evaluations that go outside really of your normal HR practices. I know that many companies have either annual reviews or biannual reviews whereby you're checking with your employees, and theoretically you're not only doing that once or twice a year, you're doing that on a regular basis. Well, it is formalized in the Form I-983 process. And so you are going to want to make sure to check in with your STEM OPT student to ensure that those are being completed, and your managers who are managing those students to ensure that you are meeting those minimum requirements. And finally, making sure that you keep track of those STEM OPT students. I think that one of the things that is necessary to understand is that this is an important extension for an individual, for a national employee who qualifies for this particular category. But there are also some rules and tricks of the trade that are very important to remember. If you can think about employer requirements, now let's kind of turn the page from an employer standpoint, what you're going to see from the employee side, but are still employer obligations nonetheless. So as you can see, it's very similar, these requirements, when it comes to general compensation, making sure that you're not going to replace one U.S. worker for a foreign national and essentially pay them less, and making sure that you are actively and actually the employer of this individual. So just sort of generally speaking, these rules look a lot like an H-1B employer would. So you're going to need to pay and compensate the foreign national employee fairly within your broad scope of wage ranges, depending on how you calculate those. So you wouldn't want a U.S. worker earning $20 an hour and pay your foreign national worker $10. It needs to be a reasonable compensation based on the work that they're doing and the actual wages within your company. Now, certainly there aren't the levels of prevailing wages as you see with H-1Bs or other visa categories, but you need to be mindful of the fact that they're looking at fairness. Attesting that the individual, this is an expansion of your workforce, not a replacement of a U.S. termination of a U.S. worker to immediately replace them by a foreign worker in this instance. And finally, the compliance inspections and labor for hire. What this ultimately means is make sure that you can demonstrate that you meet these qualifications not only on your I-9s, but also make sure that you have your I-983s completed and that you're following them. And if that you ever go off track significantly, that those amendments or updates are being made and submitted to the universities. And finally, they've got to be employed by the company. You want to make sure that if you are completing an I-983, that person is in fact an employee, will receive a W-2 from your company. I think that what it really comes down to in completing the Form I-983, again, is having a plan in place. I think generally speaking, most employers that we work with, even if your new hire program isn't, robust and the same for everybody, as I said, you will have and want to have specific goals that you have for each individual position that you have open for your headcount, and how those individuals, particularly your entry-level individuals, are going to develop and become a part of your overall workforce. And so knowing and understanding and setting a time frame for those skills to be developed, goals for each skill set to be developed, and how you're going to accomplish those goals is what the purpose of the I-983 is. But I think the one nice thing about the I-983 is it's a very realistic form. Certainly, you might not go in and have a hands-down written out program for each employee. You might have a general one that the managers are set to follow. You might have colleagues sometimes train individuals. There are many ways of having a training program. But then the nice thing is it is a very realistic view as to what you as the employer intend to accomplish over the next 24 months with your STEM OPT foreign national employee. So just think of it that way. I know that it can be a little bit overwhelming because it's yet another form to fill out for your foreign national workers. But look at it as practically, my recommendation is look at it as practically as possible. Provide information and just be mindful again of who your foreign national employees are that you've completed a training plan for. Be aware of those that may have changes in their careers path, such that you might need to file an amendment which is similar in certain non-immigrant visa sponsorship circumstances. So just again, it's the idea of once you have a STEM OPT for a national employee, you're going to need to be mindful of their career path, much like you are an individual in TN status or L1 status or H1B status. They just sort of go on your list to be checking in for those of you who manage the immigration programs out there. And finally, again, you just want to make sure that there is a nexus between the reason why you hired the individual to work for your particular company and their educational background. Just making sure that you're not out of left field. And then finally, what happens is it's a bit different than filing a formal petition with USCIS. So what occurs in the training plan, the Form I-983, is you work with your employee. It's signed by your employee and by typically the employee's internal manager. And what will happen in this instance is you complete the form, and then actually your foreign national employee submits that not to the U.S. Citizenship and Immigration Services, but to the university. And so if there are any further points of clarification, it's not as formalized typically of a process as it would be through the U.S. Citizenship and Immigration Services. It really is a more informal process whereby if the DSO at the university, the individual who's charged with reviewing and issuing the necessary documents for a foreign national student to apply for and receive a STEM OPT, thinks it's sufficient information, then they'll accept it and issue the student the necessary documents to file for the STEM OPT. If they need more, generally it's done via email or phone calls, and you can get the general instructions as to what is needed for the next steps. Again, certainly you want to be mindful of what's stated within the training programs to ensure accuracy. The fact that you're providing a fair wage for the circumstances. You do have a manager identified as the manager who will be overseeing the plan. And then ultimately wanting to make sure that the individual, if this is an internship or if it's full-time employment, that the individual is working at least 20 hours a week. So those are just some tips of the trade to be mindful of in making sure that you are ready for the application process itself and hopefully are able to complete the form and demonstrate not only the employer's qualifications, but also the employee's qualifications with ease. Now, once we have everything completed,
now you got to navigate it.
Now you got to navigate it because it's unfortunately not over. Much like many things with immigration, is you've got to be mindful of what is occurring in that particular foreign national employee's career path. So if you have a certain training plan and career path in place when the Form I-983 is submitted to the DSO at their university, and things change. For example, you thought that they were going to really be invested in pursuing software development through Java, and as it turns out, while going through the training program, and again, this is hypothetical. I am not an IT expert, but just bear with me. You thought that they were going to be a Java developer. That was their career path, but as it turns out, in the first several steps of their training program, they really took to a more quality control component, and so their training is necessarily going to shift based on the fact that they're not really going to be doing software development. They're going to really be doing quality control for the software development. If that is a career change within your company, you're going to want to make sure that the I-983 is revised to accommodate the new training plan that's in place and new focus, so that you can then reestablish the nexus between the degree that was received by the foreign national employee and the training plan as completed. Now, the nice thing is that's a coordinated effort between you, your foreign national employee, and the DSO at the university. So it's not as though you would need to involve USCIS. However, you do have an ongoing obligation to report those changes. In addition, if anything changes in sort of the typical fashion that you typically see, if there's a new work location or reduced hours or the company changes such that you have a new FEIN or even E-Verify due to a merger or acquisition. Just those are items that you would typically reach out to your immigration provider to discuss, and that those rules hold true with STEM OPT for national employees as well. So again, as I said, you're going to want those individuals under your radar, or on your radar, I should say, because the requirements that you have for other non-immigrant individuals where there's a specific employer sponsorship is very similar here. And because of the changes that were made several years ago, we need to be mindful of those changes and the requirements. So another item that is important is not only do you as the employer have ongoing requirements, but the F1 student does as well. And it's a coordinated effort, again, basically like no other in other forms, because the student has certain responsibilities and timeframes, and you as the employer does as well. And so while a student may be providing an evaluation of themselves, your employer, you as the employer, also has to agree with it and sign off on it. And so it's one of those situations where, again, coordinated effort, being mindful of the dates, being mindful of, again, any changes that may need to be made so that you and your foreign national employee can coordinate these follow-ups and ensure compliance together. Now, certainly in a circumstance where there is a complete change in the work and work authorization and relationship between you and the employee or foreign national employee, the situation where there's a separation, either by your or the foreign national student's choice. Much like an H-1B where there is a separation, you need to notify USCIS of that separation. In this instance, you're actually contacting the DSO to ensure that they're notified that all the obligations that you have based on completing the Form I-983 with evaluations or amendments have ceased. And you need to do that within 5 business days after the student's departure from the company. So that is certainly a tighter turnaround time than most, but it is absolutely critical that you're aware of that responsibility, like I said, which is very similar to an H-1B situation where there's a termination of an H-1B employee.
Great. So earlier, when you first started off on talking about STEM OPT, you mentioned this phrase, cap gap. Mm-hmm. Curious, can you explain what cap gap is and how that works?
Certainly. So cap gap is actually coordinated with the H-1B cap season. And those individuals who receive cap gap work authorization are those foreign nationals who has an EAD, whether it be an OPT EAD, so employment authorization document, or a STEM OPT EAD. Those individuals whose expiration date on their EAD expires after April 1st, but before October 1st. What happens is, if the individual foreign national employee who has this particular set of circumstances with their work authorization, the petition, the H-1B cap petition, is selected for the lottery and is being adjudicated by USCIS, that individual receives work authorization through September 30th of that fiscal year by operation of law. So, for example, if you have a student who has a STEM OPT EAD that expires on July 15th, 2019, and you submit an H-1B cap petition for her, and it's ultimately selected, and you receive the receipt notice for the H-1B cap petition, even though it'll likely not be adjudicated by July 15, 2019, your employee will have work authorization through September 30th, 2019 by operation of law. And certainly there are always unique circumstances across the board for everyone. So in circumstances like this where an individual expires, This is an example, hypothetical. I encourage you to please reach out to your immigration providers to ensure that you have the appropriate and accurate information for each individual foreign national employee, because it really is on a case-by-case, or as I should say, person-by-person basis. And finally, as I mentioned at the beginning, the importance of timely filing the STEM OPT EAG application. I think probably the most conservative path, even if you are eligible for CAP-GAP, is when the EAD expires as a foreign national student. And if you had the opportunity to file before that expiration date, even though you might be subject to CAP-GAP or might be eligible for CAP-GAP, file it then. Better to be safe than sorry. So if your EAD expires on March 28, 2019, you better get that STEM OPT EAD in on or before that date. And so, but as a backup, if you do fall into that CAP-GAP situation that I just described, you can actually file the STEM OPT EAD extension renewal application during your CAP-GAP. As that's considered work authorization by operation of law, you do have that cushion. And so while the rules are very strict and tight, there is a little breathing room for those individuals who are in CAP-GAP. And just generally speaking, because the H-1B lottery is always, or has been always oversubscribed for the past several years, if an individual employee qualifies for STEM OPT EAD, I encourage you to speak with that employee and your immigration provider to determine next best steps. Because generally speaking, if you've got an opportunity to extend, it's certainly a good idea to do so, because you just don't know what the lottery will bring, or even if selected into the H-1B, given the level of scrutiny that H-1Bs are seeing now, what that success is going to look like. So always, if you have a backup plan available to you, utilizing it is certainly the best way to go as far as I'm concerned, and generally speaking. So I think at the end of the day, if there are a few themes, that ran through this, is you've got to maintain compliance. There are a lot of additional responsibilities that you as an employer have as a result of the implementation of the STEM OPT EAD program, in particular the Form I-983 and all of the obligations, reporting obligations, oversight obligations that weren't there in the past that are there now and have been. So it is very important to be mindful of your ongoing and extra obligations if you do, in fact, employ students pursuant to the STEM OPT. Again, you've got to be mindful and keep track of those individuals with STEM OPT, much like you do individual employees who have H-1B, L, or TN status. So if things change and are significant enough to impact that particular employee's career path, location, similar circumstances, you do need to reach out to your immigration provider to provide necessary advice as to whether or not any updates need to be made with the DSO and the university. Again, you want to make sure that this individual is an employee of your company, no contractors. And so it should be a W-2 employee, very, very clearly established employer-employee relationship. And back to, I guess, points 2 and 4 are very similar. Any amendments, any changes that impact the employment or training plan that you have established, please do make sure that you're reporting them to the DSO of your foreign national employees university to ensure that everybody remains in compliance.
Compliance communication. All right, so that kind of wraps up our main presentation. Thank you, Sarah, so much for that. That was very, very informative, and we're getting a lot of questions coming in. We're just going to have to vet those before we get to them. But at this time, again, just want to, if you do have a question, please ask it. We'll try to get to it. As we kind of look those over, I just want to mention that we have 2 more webinars coming up this month. Next week, I encourage everyone to sign up for particularly, where we will take a deep dive into our 2019 Immigration Trends Report. That will be released early next week, and we'll have a webinar next Wednesday on that. Very informative, has a lot of interesting stats and trends that we're going to talk about. If you register, you will receive a copy of that report when it is released. And then we're going to cap off the month with a webinar on Brexit, March 28th. I haven't checked the news in the last hour, but I believe there's a very important vote. So join us for that webinar to kind of see where everything stands with Brexit, because right now no one really knows. So if you want to receive these webinar invites, subscribe to our mailing list and follow us on all our social channels so you can receive those invites. And as I mentioned at the top of the presentation, all attendees, if you take a look at your screen, we have continuing education credits for SHRM and HRCI, so please copy those down, or you can wait till tomorrow. These will also be included in tomorrow's follow-up email. All right, so we're going to hop into the questions. Sarah, starting off, can students travel during the cap-gap period?
They can travel, but it's not recommended. If they travel during the cap-gap period, they will not be able to be readmitted to the United States until the H-1B is approved, and they're able to, as applicable, apply for and receive their H-1B visa stamp. So ultimately what that means is that they would be able to enter, assuming the H-1B is approved prior to October 1st, they would be able to apply for their H-1B visa stamp, enter the United States 10 days in advance of the October 1st start date, but not start working until October 1st. So while sure, they can travel, in situations like this, it's not recommended so that they can remain in the United States in a work authorized capacity.
Gotcha. So you back at talking about the rules, talked a lot about the training plans. So the question is, do I have to create a new training plan for a student who begins a STEM OPT extension?
Well, it's a situation where if you have, I guess that you have to look at what your training plans look like. So if you have an individual who already has their STEM OPT EAG and joins your company, yes, you're going to have to file an I-983 for that individual. It's going to be submitted to the DSO. However, if you are slotting them into a training program that you already have, then use the information for that training program. It's not necessary that everyone is unique to the training program itself, and for every time you give, say, Joe gets this one training program, but then you give Sam another one. If Joe and Sam necessarily have the same training program because that's how your company does it, then yes, just make sure to provide the information needed, and it's okay if you've got similar training programs for your employees.
Gotcha. What should I do if a STEM OPT student is terminated?
As discussed, you're going to need to contact that student's DSO at their university to apprise them that the student is no longer working for your company within 5 business days of that separation.
Okay. Can STEM OPT students receive requests for evidence?
They can, but this is a bit of a unique circumstance. So because this is a bifurcated process, the first step of the process is submitting the I-983 to the DSO at the university, and then the second step is then submitting the I-765 application with supporting documents to the U.S. Citizenship and Immigration Services to actually get that STEM OPT EAD issued. In the first step, submitting the I-983 with the universities, as I said previously, it's not really a request for evidence formalized process. It's more of a communication between the DSO and the student if there isn't sufficient information for the DSO to finalize and accept the I-983. So yes, more information can be asked, but no, it's not as formalized as a request for evidence process or RFE process would be through USCIS. So there's that step. In the second step, once the employment authorization application or the form I-765 is submitted to the U.S. Citizenship and Immigration Services, certainly in that application process, if USCIS needs more information, they can issue a request for evidence.
Okay. And we're just going to take a quick second to kind of vet. We have time for about one more question. A lot of great questions, but some of them are you're going to need very specific and just can't answer at this time. So for those, if we don't get to it, please ask your immigration attorney. So just give us one more second here.
So, just generally speaking, if you have a foreign national who is in OPT status and the H-1B has been selected, but they're working for the CAP, but they're working pursuant to CAP gap, and you don't have a decision by October 1st, then typically the general advice is, and again, this you would need to specifically speak to your immigration provider for specific advice to see what alternatives you may have, would be to place that individual employee on an unpaid leave until the H-1B is approved and the individual employee can demonstrate work authorization. I can say also that when I mean contractors, I mean individuals that are placed as contractors at your location, meaning they are not your employee, they are not your W-2 employee, they are somebody else's employee. You want to complete the I-983 only for your company's employees. That's what I mean by that. And I think that at this point in time, there are a couple of other specific questions that I would recommend. Please do speak to your immigration counsel so that you can understand specifically what's going on for that particular employee and you get the support that you need.
Great. All right, well, that's going to wrap things up for today and our webinar schedule for this week. Sarah, thank you so much for not only this webinar, but also the one earlier this week. It was a very informative presentation. Again, everyone who's currently listening in, you'll receive a copy of this recording and the slide deck tomorrow afternoon, so please keep an eye out on your inbox for that. So with that, have a great rest of your day and have a great weekend. Thank you.
Thank you.